Yes, ready? This is legal matter at the rate of 100 words per minute. Yes, start. The appellant is aggrieved by the judgment and order dated 12th November 2009 passed by the Delhi High Court in contempt case number 449 of 2009. By the impugned judgment and order, the High Court held that the respondents had not committed any violation of the order dated 12th November 2008 passed in WP number 7971 of 2008. Para, in her aforesaid writ petition, the appellant had made several prayers, but during the course of hearing in the High Court, 5 of the prayers were not pressed with liberty to take appropriate proceedings in accordance with law. The 6th prayer, which was pressed, related to respondent number 2, that is Ashok Chaturvedi. It was prayed that he should be asked to proceed on leave pending the independent inquiry into the appellant's complaint of sexual harassment, so that this respondent could not use his power and authority to influence any independent inquiry. As will be evident from the prayer, the inquiry relating to the allegation of sexual harassment made by the appellant was already pending. In the order dated 12th November 2008, a direction was given by the High Court to expeditiously conclude the inquiry. The appellant had complained of sexual harassment by her senior Sunil Gupta, Joint Secretary in the department, and Ashok Chaturvedi. The allegation of sexual harassment by Sunil Gupta was looked into by a committee constituted for this purpose. The committee gave its report on 19th May 2008. A separate inquiry was held by a separate committee into the allegation of sexual harassment by Ashok Chaturvedi. This committee gave its report on 23rd January 2009. Para. In the contempt petition filed by the appellant in the Delhi High Court, it was brought out that the committee inquiring into the allegation against Ashok Chaturvedi had since given its report. It appears that pursuant to the report, an order dated 22nd September 2009 was passed against the appellant, but the disputed that this order was based on the report. Be that as it may, the controversy that arose during the pendency of the proceedings in the High Court and in this court related to the entitlement of the appellant to a copy of the report dated 23rd January 2009. The High Court did not pass any substantive order relating to furnishing that report to the appellant. With respect to furnishing the report dated 23rd January 2009, an affidavit has been filed on behalf of the Union of India, claiming privilege under Section 123 and 124 of the Evidence Act. We have been taken through the affidavit dated 22nd July 2010, and all that the affidavit says is that disclosure of the contents of the report would be against national interest and would compromise national security. Apparently, this is only because the appellant happens to belong to the highly sensitive organization which is entrusted with the delicate job of collecting and analyzing intelligence inputs necessary to maintain the unity integrity, and sovereignty of the country. Both the reports and the accompanying documents have been filed by the Union of India in a sealed cover in this court. Stop and over.